In fact, one of the most common pitfalls, and I'm hoping, Miss Joseph, you could start with that today, is for me, I've seen a pitfall to be taking too long or waiting too long to prepare your will, coming to us very late in your life and then insisting that we get something done quickly, either for you or for a a loved one, because you recognize that the hour is upon them. Miss Joseph, has this been
Yes,
your experience thus far, and how can
to
this prove to
avoid
be
it.
particularly difficult? Putting attorneys in a
Avoid.
position. Mhm.
Yeah, well, we can deal with that. But just to back up what uh, Onika and I had started doing, we were looking, jumping in and picking up one or two questions while we are
Questions.
waiting. So we dealt with, somebody wanted to know what was it? Let me see. Uh-huh. He was helping, he is working with his wife. So I wanted to complete that.
Okay.
Brendan Best, I don't leave him hanging, and then we'll come to the common pitfalls.
Sure,
I'm
no
a young
problem.
professional building my estate with my wife. Are there any good books? So we told him, why go to UK law, UK case law, very good because we're Commonwealth country and you can learn a lot from reading the cases. So yes, so we plunge right now into common pitfalls, but I'm seeing a question from Alicia that is relatively easy to answer. How
Yeah.
long does it take to probate a will? Alicia, let's say at least 1 year for an uncomplicated will. That's a nice, short, easy answer. Shahida, I would ask you to kindly rephrase your question. It's a little bit convoluted. And then let me now just take the
Marva.
common
Marva
pitfall.
has a very simple question as well too,
Okay,
but
I saw
I'll let
it,
you know.
The
Yeah,
will is null
it's
and
just
void,
wooden.
did not have to right.
Yeah,
That is
simple.
it's not a common pitfall, but it can happen from time to time when people do not know what goes into making a will a legal, valid document. All right, the intended executor is trying to reach next of kins who live abroad and a very distant family, but to no avail. What is the next move? I have understood that it remains still for the next couple of years. Is this correct? All right, let me unpack. Wow, Miss Aruna Bisessa, let me unpack Martha Selman Cooper's question, and then we need to go to the first common pitfall about waiting too long to write your will. All right, the will is null and void. So it has no signatures. So therefore then, the important point there, Miss Salman Cooper, if there are no two signatures on the will, you are absolutely correct. The will is null and void, and so therefore then this
The
person died
person is going to
intestate.
intestate. So,
And so, therefore, then the issue of intended executor or otherwise does not arise because you cannot go forward with an invalid will. So, Miss Marva, the best way to treat with this, and the only way to treat with this, is accept the fact that the person has died intestate and you have to proceed on their estate by way of letters of administration. Aruna asks this a very interesting out of the world question. Can someone who had their tongue removed and cannot speak do a will? The short answer is yes. The critical thing is that the person has the mental
yes, yes.
competence. And that will take me right into one of the common pitfalls,
Beautiful.
right? Writing, taking too long to write your will.
Yes.
Now,
Before your
just
tongue is removed.
so because the tongue is removed is similar to a person who may have lost his ability, maybe deaf
To
and dumb or
see
something to
what's
that
yes,
effect.
yes.
So the first thing we want to note is that one of the first clauses one meets in a will is where you say, I have revoked all previous wills, and you say, I am of sound mind. And what we find happening is that many persons think when they are about to write a will that they will die. They saw a black cat on the wall last night, impending death. We
Hmm.
want to immediately rubbish that idea. Uh, Preparing a will is no evidence or any indication, or does it in any way lead to death. What we find happening is too many persons wait till they are gravely ill to prepare a will. And in so doing, one of the most common pitfalls it would be the fact that they no longer have the mental competence to write a will. And just like the person who may have lost his tongue, they may have also lost their ability to use their hands to sign a document. And they may have to use a thumbprint. And once you move into that realm, there are certain very, very important legal terms that must accompany such a will. And unfortunately, the ordinary person will not know these things. And so, this is why, from the word get go, we are suggesting that you put your will, the writing of your will, in the hands of a competent attorney at law. And there's another pitfall about waiting too long and too late in the day. You may not remember what you have. And we have had several instances like that. A particular gentleman, he opened a unit trust account 20 years ago. And he waited so long to write his will that he forgot he had the unit trust account. He forgot that he was no longer on speaking terms with the relative whom he made the beneficiary, but it was too late to change it. So we are suggesting you make a will when you have a fair amount of mental competence, mental acuity. You know what you have. You know who you should pass something on to. And you also know who has an interest in what you have left.
Correct.
Because to do otherwise, you may find yourself when it's too late and you cannot do anything about it, when you are 6 feet or 9 feet under, or you may have been cremated, when your will and what you thought was a will is invalid and cannot stand the test in the court. So you want to
Correct.
avoid that. And only an attorney, really, only an attorney can help you ensure that that happens.
Yes. And so, again, I want to reiterate, when writing wills, even though you can do it yourself, as Miss Joseph and I would have said time and time again, you need to consider, as I refer to it, the back end or the consequences of probating what you have written. All right. Which leaves us to another common pitfall I wanted to mention this evening, Miss Joseph. I know you said it was going to be point number 3, but I want to take it as pitfall number 2, because I saw a question that this falls in nicely with. Erlyn Stanford said, and it's
Yes, I'm
very
looking at that.
interesting.
Yes.
Yes, she said, "Good day, please help with this scenario. Her husband wrote a will and did not put the married home in the will, thinking that it will be safe and that the wife will get the house. However, when he died, the wife lost the house due to something called residuals. Please explain." Interesting. And I assume that she's talking about the residuary clause.